As you are entering, if you could, please leave your name, your location, and what organization you're with, or if you're an individual, just say, I am here to learn. Leave that in the chat so that we know who you are. All right, we are going to go ahead and get started today. My name is Sharice Wilk. I am one of the board members for the Black Innovation Leaders of Florida. We have 4 of our board members on this call today, in addition to our collaboration team with the USPTO office. I will let those board members introduce themselves if they would like to come off mute and say something to everyone that's in attendance today. First, we'll start with Lloyd.
Welcome, everyone, and we appreciate the USPTO office for this great opportunity to learn, and I think it should be pretty rewarding for the folks who are attending.
I guess I'll go next. Hey, everyone. I'm so excited for us to start this journey. I know there's going to be so many nuggets that you all are going to share. Don't forget to share out and your enthusiasm and just really how much you're leveraging from this opportunity. We definitely want to get your feedback and know how you're growing through this experience and how you believe this is going to impact the work that you do and take your business and those opportunities to the next level. So please stay plugged in with us. We want to hear your feedback. And I know there's going to be some great things that are shared. So ask a lot of questions, like lean in, ask a lot of questions, engage. I tell people all the time, you get what you go after. You get what you go after. So I want y'all to go after it today and lean in and ask several questions. There's no hard questions. There's no silly questions. There's no stupid questions. Just put them all out there so that we can truly help everyone to make that dynamic shift that they need to make for their ideas, their inventions, their thoughts. Let's just put it all out there. All right, I'm excited about this. I know you all are excited, so I'm gonna shut up. All right, have a great time.
All right, I am back. Had internet problems, so that's why we have backups on here. All right, so if we could have an introduction by our USPTO officials, then we'll start with Gotham.
Good afternoon, everyone. My name is Gautam Ubale. I'm a primary patent examiner at the office and also currently assisting as an outreach coordinator. And I also have my colleague, Ramon Mercado. He's also the similar roles as me. And he's also with me in the outreach coordination role as well. And just to give a little background of myself, I am a primary patent examiner too, which I work in digital marketing area of business. And Ramon does in computer storage. I think, is that right, Ramon? Computer storage? Yep. Okay, perfect.
Yep.
So that's our introduction, but feel free to ask questions in the chat. Ramon is going to help us. And the questions that don't get answered during the presentation, I would answer at the end of the slides. And yeah, if you feel like you have a burning question that you need to ask, please type it in chat versus while presenting the presentation.
Okay, and really quickly, I am going to go over a quick presentation about our IP Launchpad program for the Black Innovation Leaders of Florida and why we are doing this. And then we will go ahead and get started with the presentation from the USPTO. Oops, wrong screen, excuse me. All right, so for the IP Launchpad, the Black Innovation Leaders of Florida are here to help with educating our community members, of course, and any of our allies who are willing to help build the innovation ecosystem for our Black inventors. or anyone working in the entrepreneurial space here in Florida. And so essentially what we heard through our work that we did last year and on our innovation tours around the state was that a lot of individuals and existing business owners wanted to know more about protecting their intellectual property. And so out of that, as board members, we got together and decided that it would be best to educate our members and build some partnerships to help further strengthen and protect our intellectual property as we all are working in this innovation space. And so out of that, our program was born, which is called IP Launchpad. This is not moving forward. So with this, our goal is aligning the Florida Black innovation ecosystem for success. And so as we know, intellectual property is a key aspect for economic development, and we want to make sure that our businesses are protected. So why are we starting this program? Basically, it's also due to the statistics around patent and trademark application filing. So for patent applications, we know that 12% of the filings in the previous year, I think it was 2022 or 2023 with this data, there were only 12% who filed that were women. The next population was 24% of those patent applications that were filed were minorities. Out of that group, Asians made up 18% of the 24% of patent application filing. And other minorities, they were at 6%, which means that there are some barriers to entry that may be present, and more information must be given to educate people on how to file more patents and trademarks. We found also across the nation that on average, patent application costs with attorney reviews or filed by attorneys may actually cost up to $25,000. And so that can be a barrier for new startup individuals and or businesses who don't have the sufficient budget. So as a result, we have decided to launch a year-long IP Launchpad program. And the first cohort is going to be these first 4 classes offered during August and September. So today you are here to learn about intellectual fundamentals taught by Gotham. So this is where you're going to explore the different types of patents and what the differences are, what's the difference between provisional and non-provisional patent applications, and discuss the roles for the U.S. patent examiners and what to expect when working with the USPTO. Next week on Tuesday for the Lunch and Learn, you're going to hear about a lot of the different USPTO offices, such as their partnerships with universities and other entities. And then we're going to go through a little bit of a deeper dive on patent basics and trademark basics. If you are a member of Black Innovation Leaders of Florida, we will have a second part of this program where those who have attended all of the sessions for cohort number 1 will be applicable. They will have the opportunity to actually apply for access to get trademark and patent applications filed for them with one of our partners who has software that helps file your application. So we have 10 slots available for trademark, and then we will have 6 slots available for patent applications. And then if you want to continue your education, you will have access to a learning center from our partner. And then you can also continue your education through Black Innovation Leaders of Florida, as we are going to have a series of classes offered throughout the remainder of the year that will start back up in November. And so for cohort 2, we will go through the detailed 8-part series of the path to filing your patent application. We're going to go back over trademark, maintaining your trademark if you already have trademarks that are in existence or that are approved. And then we're going to also get into copywriting basics with our partners with the U.S. Copyright Office, and then how small business owners could do business with the USPTO office. And so that's what we have on the agenda. And these classes will be advertised if you are registered with us on social media, as well as our newsletter, and you'll be updated when these classes start. All right, so with that, I am going to stop sharing and we can go ahead and get into the class.
Let me share my screen. Can you guys see my screen? Perfect.
Yes, we can.
Great. Obviously, I already introduced you guys. Welcome again for this intellectual property fundamentals. We'll go through the slides. So this is just a basic disclaimer that we always let everybody know that this presentation is only for informational purposes only and should not be considered as a legal advice. It is crucial to seek any guidance from relevant authorities to ensure legal validity and accurate advice on these issues. So our discussion topics would be, does intellectual property have a value that can influence investors' sentiments, right? In my opinion, the IP strategy of a company serves as a crucial indicator of success in R&D, which is research and development. It can reveal companies' ambition, vision, ability to capitalize on its research and development efforts. So companies focusing on IP tend to have more resilient and enduring presence. However, they will also outperform and other who remains unanswered question in the field of intellectual property. So we'll go over some of the topics, which is trade secrets, copyrights, trademarks, patents, and then there is some resources. So here are some key points to help you develop your strategy for if you're a small business owner or a small entrepreneur. So how many of you guys have seen the CNBC show Shark Tank? You can put it in chat or whatever. But if you have seen that show, you would know that the sharks, usually those four guys, would ask if anybody possesses any kind of intellectual property. And usually when people do possess something, they kind of, say that we have a patent pending or we have filed for, the application with the patent office here. And usually that just sets you apart from others who don't have any, because that gives you a leverage to basically promote that you're serious about your stuff, right? So that's the whole idea of this slide, where why is intellectual property strategies a good business strategy for you? What are the advantages, right? Basically, once you have a patent, it will deter others from getting that, right? It's gonna also expand your market opportunity. It will also give expansion to new territories. Intellectual rights also help you, depends on the countries that you want to work with. If you are going to manufacture a widget that's going to be utilized throughout the world, then you might as well file for those applications in so and so countries. And the other thing it will also help you is it will safeguard your intellectual rights for limited time frame. Again, is this global? There is nothing called global patents. When you file for a patent, it has to be filed in each country. And there is a provision for that too. How do you do that? And we can go over that when people have more questions. So what is intellectual property, right? On the left side, you see, actual house with a fence. So just think that that fence that's going around your house is the protection that you get, basically. Same goes with the intellectual property. It's basically an intangible creation of your intellectual mind. And the main goal is to basically stimulate the development and a wide array of intellectual goods, basically. So individuals and businesses are given property rights for the information and creative work that they produce, usually for a limited time. So this rights basically encourages the creation by providing financial incentives and safeguarding your ideas from unauthorized reproduction, basically. So what is U.S. Patent and Trademark Office, right? We are the foremost agency dedicated to fostering innovation and driving economic growth while maintaining a reliable and predictable, high-quality intellectual property system here. USPTO also accomplishes this by issuing patents, which grants the holder exclusive right to their invention, and by registering trademarks and service marks for products and services. So this is the data from the last year of how many employees are within the patent office. We are almost 13,500 employees within the patent office in the USPTO, I would say, because out of that, 8,500 are patent examiners, 750 approximately are trademark examining attorneys, and then we have 200 plus administrative judges, and then we also have other trademark judges, 28. Last year, this was the data from last 2023 that talked about 650,000 applications were filed within the patent system, and almost more than half were issued a patent. Same goes with trademarks. There were almost 737,000 trademark applications. Of 50% and more were issued the certificate of registration. And finally, we are headquarters in Alexandria, Virginia. This is where me and Ramon are basically doing our outreach duties. And oh, I forgot to mention also, I am based out of Orlando, Florida here. So, and Ramon is in the Virginia area around the DC headquarters. So we'll jump into a little bit of historical foundation if, some of us might be curious where it all started, right? So from early patent laws to modern trademark protection, the concept of intellectual property has played a crucial role in fostering innovation and protecting creators' rights. As technology has advanced, the importance of IP rights in various industries have become very significant. So the constitutional provision reflects the founding fathers recognized that the value of protecting this intellectual property is a means of encouraging progress and creativity. So by granting exclusive right to the creator and the inventor, the government incentivizes innovation and ensures that society continues to benefit from new ideas and advancement. So types of intellectual property, there are 4 of them: patents, trademarks, as you know, let me grab my trademarks, copyrights, and trade secrets, right? So trademarks basically plays a crucial role in safeguarding both brands and consumer, just by identifying the origin of goods or services. They provide customers with the assurance of knowing the source of the product or services that they engage with. If you think of Apple Music, that's a service that Apple offers, right? So that's into trademark. Again, Apple logo, that's a device that you can just associate a product. So those are trademark too. And we'll dive more into trademark in the next few slides. And then comes these copyrights, which protect creative works such as music, books, choreography. And the term for copyright is the life of the author plus 70 years of death. Work made for hire, anonymous work are protected for 95 years from publication or 120 years from creation, whichever is shorter. And then finally, we have the trade secret. The trade secret basically just sounds like you just keep it secret. You don't let it out. That's how it works. Are we doing so far so good?
Yes, we are.
Okay, great. And so here's the perfect example. Just within one Apple product, means if you think of all these stuff that they might have, they have trademarks. As I mentioned, Apple name and logo. iPhone name, that's trademark too. Patents, they have multiple patents. They have data processing methods. They have semiconductor circuits. They have chemical compounds. They have antenna, glass display. And there's many more, but this is just few of them that I've listed here. Then they have copyrights, their software code, their instruction manuals, their ringtones, that can all be copyrighted. And then they also have the design patents, which is basically, how they arrange their lenses, the placement of their buttons. So every time they change their design every year, they have a design patent also simultaneously. And then they have trade secrets, which obviously I don't know. If you guys know it, then you guys are golden with it. But usually you will never find out.
I would think Gotham, their maybe operating system or something might be considered a trade secret. I'm just guessing there.
There could be. And the way, so Google's search engine is a trade secret. They do not have that software code basically out to public showing how they are performing the list of, when you're searching something, it's going to spit out what are the recommendations. That is a trade secret till now. So that we know it. So same way Apple might have something that we are not
For
aware.
Safari. Yeah,
Yep.
so for Safari or some of their other unique activities. Okay,
Yep.
thank you.
So let's quickly talk a little bit of trade secrets. So trade secret refers to basically a confidential information that holds value due to its unknown nature. So here in example, you can see the ingredient and recipe for KFC. I'm guessing everybody has had KFC, right? And they have that unique recipe that's been trade secret. Nobody knows it. It's like, I think it's somewhere around 17 herbs and spices that are blended together to make that spicy KFC chicken. Same goes with Google. I've just mentioned about it. So the Google search algorithm is a trade secret. And obviously Coca-Cola, right? The Coca-Cola's recipe still is a trade secret. Nobody knows it. And there's a perfect great example of Coca-Cola. When Coca-Cola went into India, they captured a company called Thumbs Up, and the authorities up there said that we need your recipe. And Coca-Cola said, sorry, we're not going to give you. If you want to collaborate, we can collaborate, but you're not getting their recipe. And till date, they never got the recipe out of them, how they make their Coke products. But they do make other products that they were doing in that country. They just put their brand name Coca-Cola on top of it at this point of time. But yeah, they really are safeguarded. Maybe 2 or 3 people would know it. And again, trade secrets can also be just a company's client list, which they want to keep confidential. So that could be trade secret too. So why use trade secret, correct? So trade secrets are maintained within companies' confines and are generally protected by signed agreements between the employees and the company. These contracts may require non-disclosure of proprietary information, non-competition after leaving the employment. And this all falls within the level of reasonable effort to maintain secrecy and to keep the information out of public domain. How can you achieve this? You can have regular audits, identify any potential vulnerabilities that can help prevent anybody reverse engineering or unauthorized disclosures. There was also a Defend Trade Secret Act of 2016 that empowers trade secret owners to file lawsuit in federal courts in cases of misappropriation. So if a former employee departs and discloses your trade secret to a competitor, this act will provide a legal recourse to protect your intellectual property. So now we're done with trade secret. Let's jump into copyrights. So copyrights basically gives you a legal protection for your original works of authorship as soon as an author fixes the work in a tangible form of expression. So this encompasses a wide range of expression, could be songs, movies, books, sculptures, paintings, architecture, many more. It means every day that pictures that you capture from your cell phone, those can be copyrighted too. But we share it, we share on social media, but you can't go after people because you haven't filed actually to protect that image. That's where it comes. But it has, the other caveat to copyright is anything that needs to be copyrighted has to be affixed to a tangible medium, basically. So Copyright Office is the part of Library of Congress. It is under the Secretary of Commerce for intellectual property and also has oversight authority on copyrights. The term of copyright generally is life of author plus 70 years or 95 years from first publication for made for hire. And the filing fees for, I think, single author is around $45, otherwise $65, but you can find all that on the copyrights website here too. So again, what is copyright? I mentioned about it a few times. It basically allows an inventor or whoever, the owner, 70 years of protection after the death of the author, or it also endures a term of 95 years from the year its first publication or 120 years from the year of its creation, whichever comes first. And again, it includes literary, dramatic, musical, artistic, but it has to be on a tangible form. Yes, curious.
We have a question from the chat. Victoria asks, how can copyright owners defend against AI gathering their work as source material?
So I'm trying to think if, and again, copyright. So there is, my understanding would be if you have to copyright something against the AI, there is, I think, a debate going on the AI generated content under copyright law right now, and it's a very complex issue. So it's basically will require a lot of careful consideration for the creators and the developers. So as the AI technology advances, it's gonna make the lawmakers and the legal scholars to address these challenges. So it's gonna be, we have to just see how it goes. But there is no definite answer that I can give you on that. Hope that helps. Okay. So we're gonna move on again. These are some of the examples of copyrightable work that includes, songs, books, sculptures, movies, poems, software code that we talked about. So you can also find copyright notices on majority of the company's website, which are usually positioned at the bottom of the web page, along with the legal disclaimers and terms of use. So if you scroll down at the bottom, you will always see some of those things too, if you ever have to explore. So again, we talk what works are protected. The copyright protection only extends to both published and unpublished work as long as they meet the criteria for originality and the fixation on a tangible medium of expression. So it has to be fixed on a tangible medium to get copyrightable rights. So let's jump on to trademarks now. Does anybody know the difference between this TM and the circle R? There's no right or wrong answer. We are all learning here. So go ahead, Jervis.
I will try. So my understanding was the TM is once you put that particular piece of intellectual property into service or you're using it, so you would then be able to utilize the TM symbol. And then you cannot use the R, which is your registered trademark, until you actually have approval and authorization from the USPTO office.
That is exactly correct. And TM also is very state level. So let's say if you were operating let's say in Orlando, so you are only assigned within the state limit. So you cannot use that product or service outside the in Georgia or something. So that's when this registered circle will help you, nationally help you. But I think we will go through those slides. But great. Thank you.
I did not know that. However, do you have a slide on also like service marks? Because I recently heard something about being able to use that as well.
So it's the same thing. It's TM and wish we should have put SM here too. So SM is the same thing. It's just a trademark. So if you see here, there you go. So if you see TM, SM, and then the registered. So trademarks are associated basically to products and goods, right? And service mark is basically Apple Music. That's a service. So that's a service that Apple is providing. So they have a registration on that too. And that's when you can put the circle R for either the service that Apple is giving for the music or the news, and then the trademark for their product and devices. Make sense?
That's
Great.
to me.
So anyways, let me again, I'll reiterate this. So trademarks are basically is to identify a word name that associates to or connects to some service or goods where the source is coming from, right? So if there was no identifying mark that distinguished the product or attributes from one another, we have difficult time finding what we really liked or needed. So like, let's say you came up with a slogan and you want to trademark or whatever, you can't, right? Because that slogan has to be associating to some kind of goods or service. So just do it. That slogan, we know exactly it's Nike. So because we know it's related to shoes, so they have that file for trademark and service mark that way. And they have a registration on it. So again, here are the few examples. You see Macy's, you see the Michael Jordan's here. That is associated to Nike. When you see Jordan, you know it's Nike shoes, AAA service, McDonald's, Apple logos. So those are all the examples of it. And then, so what do trademarks offer here, right? So trademark basically offers a legal protection and exclusive right to that brand or a logo, ensuring that others cannot use it without your permission. Trademark also provides the recognition and differentiates your products and services from competitors in the market. So using the symbol R basically lets people know that you're officially registered with US Patent Office here. And this helps you strengthen its legal protection, ownership, and provides robust reassurance. So again, this symbol also serves as a visual cue to consumers that the brand is established and reputable. And also, you can register the trademark with customs where they can prevent unauthorized imports or exports of fake goods with their marks come into the country here too. And it's a very minimal fee that you pay with a custom and broader protection up there. So again, these are the several types of trademarks that includes the word mark Coca-Cola, design mark, you see special form mark, and then the composite mark. So this is just all related to Coca-Cola, what all trademarks they have. When you see this, you know it's associated to a Coke product, basically. But if you don't have any product or service and you're just trying to trademark something that people don't associate to the service or goods, then you can't get it. You need to really have something. And so these are the other examples of trademarks. As you said, it can be words, slogan, symbol, designs, combination, product packaging, product design, trade dress. So trade dress is basically when you walk in a mall, when you pass through the Apple store, you know that's Apple store. The way they have set it up, that trade dress, they have a registration on that too. So you can do that. Same Sephora too. Sephora's whole layout is trade dress, and Macy's tried to copy them long ago to really create, and they basically were infringing on the Sephora's model, the layout. So that's where the registration really comes into helping the individual and the businesses. Again, Kisses, this one, that's also, designed, trademarked. Tiffany's blue box, as we said, talked about color, there it comes with that. So before we jump into patents, I didn't give enough information on trademark, but as I told Cherise, that trademark, when you put TM, it's only within the state. So if you want to expand your business outside the Florida state level or wherever you are located, it's where it is always advisable to register, because if you're going to conduct business in all 50 states or 2-3 states also. So depending on how you want to expand, basically. Yep, Cherise.
I have another question. So I know, for instance, within the state of Florida, they have their own trademark application. How would a state application differ from the USPTO office, or will the federal, obviously, application, I know that will supersede it at some point, but can you explain what the difference is?
I'm not sure about the trade, because the trademarks TM logo, you could use it like when you start a business and you're already using it. It's basically when it's in use, you have the rights to that TM. Now, let's say somebody, my understanding would be, to file into Florida would be to get a date, right? So let's say people had same Apple, hair cutting salon, and one started with Apple, what do you call, I'm trying to think. That's hair cutting is a service that they're offering, and Apple is some kind of product that they are selling, let's say goods or services. They both can register. They both are differently providing different goods and services, but they cannot copy what Apple's logo look like, because Apple will come after it. But going back to the Florida's application, I think it might just help you in the Florida state, if whoever came up with that first business name or whatever it is, in that aspect, my guess. But I'm not 100% positive on it, because I don't specialize in trademarks that much versus patents.
Okay, thank you.
Yeah, I don't. I got to look into that a little bit, and I can forward you the information once I find out more on that.
Oh, no problem. I'm not sure if every state has an application. Again, governments sometimes come up with things or for fees. I would assume, obviously, if you're using it, you can file the date that you started using it within the state and then file for the federal application later. But I just thought I would ask.
Oh, and once you file, so the best thing is, because the federally filing trademark is per class is $250 and $350 if you do not know what class it falls under. Then the trademark examiners will figure it out, but that's where you pay that extra $100. That's where, and filing for a trademark registration, the application fee within patent office is very minuscule, like $250 and $350. But then if it's complicated business that you're doing, then we always advise that you hire somebody, a legal authority who can help you with the process, basically.
Okay, there are no questions in the chat, so we can move forward.
So let's get into the patent, which is the majority chunk of it too. So what are patents, right? Patent basically provides you a legal power to prevent others from making, using, or selling your invention within the United States or importing into the country for a period of usually 15 to 20 years. And in exchange, you're disclosing your details of invention to the public, basically. So this gives you exclusive right that allows you to protect your innovative ideas and investment and gives you a competitive advantage in the market. Again, there is no such thing called worldwide patents. But however, if you want to sell your product outside the United States, there are some agreements with the Patent Corporation Treaty, which will allow you to basically file in multiple countries that same application. And there is a time frame for all that to really make it happen. So these are the three types of patents we have. One is utility, design, and the plant patent. So utility patent basically protects the new and useful process, machine, composition of matter, or any improvement to the existing invention. So like when Apple comes up with new phone every year, they're just making a slight improvement into their product, right? And then they file for patents on utility patents on that. Again, they also file design patents because they might change the layout of the phones or the cameras locations. So that's how they take advantage of those two patents. Then the design patents basically covers the new original ornamental design for manufactured article. And it also protects the visual characteristics of an object, ensuring the aesthetic appeal is preserved. And lastly, the plant patent. It protects the new variety of sexually produced plants. And so if you know avocado, the Haas avocado, those are plant patent. They have a plant patent of, the texture, how smooth it is created, the avocado, they have a patent on that. And usually utility and plant patent, they get 20 years of protection from the date of filing, while design patent are only valid for 15 years from date of issuance. So those are the little differences between them. So far, so good? Great.
I have a question really quickly.
Sure.
With the expiration of those patents that you just showed,
Yep.
When those end, do your utility applications or your designs, are those public information after they expire?
Yeah. So I think we will jump into provisional, but I'll give you a little cap. So once it's published, it's publicly available. Everybody has
Okay.
If you Google search, you will see it because Google Patents has the whole database. Anything that's published on internet, it's going to be there. That's why you have to be very careful. If you have some kind of invention or anything, you want to make sure that you do not go and put it on social media or any articles or universities or presentations also until you really take advantage of the provisional patent, which we will talk about it and how it will help you.
Okay, so again, once this process expires and it's 15 years from the date, if I wanted to make an improvement, I'm kind of thinking like how you mentioned Apple does it.
Yes.
Like they will make an improvement every year upon something. But if I took one of their took one of their applications and I had an idea to make an improvement, I could utilize the functionality of that application and then submit my own?
Yeah, you can.
Okay.
Yeah. That's where the race happens is, let's say you took Apple's something that you improved on and you thought this was great. And there was somebody else also did the same thing. That's where the dates come into picture. Who filed first with the patent office versus, and it also gives you an edge when you do a provisional, and we will talk that too. So it will all come together once we go through a few slides.
Okay, really quickly, we have one other question. Frederick asked, how does the USPTO assist US companies in defending their patents against foreign infringement?
How does USPTO, can you repeat that question again?
How does the USPTO assist US-based companies in defending their patents against foreign infringement?
I think so it purely depends, right? So Apple has what do you call patents throughout the world, basically. So they use the WIPO system called WIPO, which I talked about, PCT, Patent Corporation Treaty. There are, I think, some 200 plus countries. So they have gone and check marked and filed patents in each country, so they can enforce those rights in those countries too if somebody has to infringe it. Now, when it comes to just nationally here, if your product is just going to be serving within the United States, you're protected here if somebody is trying. So example would be, there are many ways to protect that. And I think I have a perfect example because I met a lady in Florida who came up with a product for a gym, which helps assist weightlifting. And what she came up with that product, she filed a patent file within the US and started getting manufactured in China. She sold her product for the start of the year, I would say for the first 2 months on Amazon. And then suddenly she started seeing that her product on Amazon sold by somebody else, but a different color. So basically, she did not know till somebody put it on TikTok. And she said, my product is not pink. It's, a different color. That's how she caught. So the only recommendation I had to tell her was, because it was serving only US she filed in US and she wanted to, and the product obviously is getting manufactured in China and they're duplicating it and forfeit, bringing it and selling on Amazon. The only advice I could give was first to contact the Amazon's legal team because they have the whole information underneath you can contact. Secondly, she should have registered with Custom and Border Protection with the US patent filing, and the fees are literally, I think, less than $200 to register your product. So that would have also stopped that product entering United States. So those are the few things that I would think of, and I had recommended that person. Hope that answers.
So just to clarify, if I heard you correctly, you said that if you're manufacturing anything overseas, you need to make two filings, one with the US PTO office, and then one with Borders and the Customs office as well.
Yes, because that will help you to protect your product not entering the country, so nobody on Amazon or anywhere else can sell it, basically.
Okay.
That would be the two things that I would definitely encourage, So again, this is the perfect path for talking about somebody stealing your ideas, right? So when you think of something, you have an idea, the best thing is to first go and do your own comprehensive search. And that's where this presentations that we are giving and that patent, that 8-part series that we also have every quarter runs on USPTO's website every Thursday. And they go in more depth about how to do all those 8-step process to really file for your patent application. And in the resources, you will also find more stuff when you need some local help here too. But again, going back to this slide, when you have an idea and you've done in search about that idea and you don't find anything, and you think that your idea is novel and worth pursuing, so that's when you basically encourage to file for this provisional application, which is optional. And this is where it comes handy. So let's say you came up with something, you created a presentation slide. I would highly recommend that you file for a provisional application with the patent office and then go present it. So now anybody who seen that publicly available presentation, they can take that idea or whatever you have, have thought of to basically go and file for it and claim that it was theirs, because now officially you are registered with us. And that's where the provisional application is so helpful. And again, provisional application fees are so minuscule that they are hardly anything. And for small business owners, individual people who don't have more than 4 patents, so micro entity basically, their fees are almost 80% discounted. So if it's a $2,000 application fee, 80% of that is what the fees for individual inventor would be until they hit their 4 patents they receive, and after that it becomes a small business. And that small business also, I think the fees are I think 60% discounted. So still, filing for a patent application, you're getting still small businesses 60% discount. So again,
So Gotham, really quickly with those discounts, because that was a very important thing that I want everyone to hear
yes.
and remember on this presentation, that obviously, again, we talked about that cost with the applications at the beginning, but obviously there are ways to get those costs discounted. So he said if you had got under 4 patents that you need file, you can get an 80% discount. And then if it's over 4, based on, I'm assuming, your business revenue, you can get up to a 60% discount. So just really quickly, is there a separate application process for people to access those discounts?
And there, so on our website, when we hit the resources, you'll see, and we should have the links for it. And
okay,
they also have to qualify under the federal poverty, income level. So it's all, there's all kind of check marks that they have to go through. But usually you can take advantage of all this, basically.
Okay, so there is a way to get the fees reduced.
Yes.
All right, thank you.
Yep. And so the whole idea of provisional application is you get a 1 year before you file for non-provisional application to really work out everything that you need to improve or make it a perfect product. That's where you get that 1 year to really work on it and also establish the filing date, which is very important. We talked about it, right? For plant, patent, and utility, it's from the filing date. So you get that protection from that way. And then once you get your non-file provisional application filing date, you see that 20 years time frame, you get 20 years protection once you officially file for non-provisional. So here are the perfect differences between them, right? So the main distinction between the provisional and non-provisional is the cost-effective option that lets you secure the filing date for your invention without the need for claims. You don't need to have claims. It is also important to note that provisional application is not published or examined by the examiners. So simply filing one will not result in actual patent, because we will not see this provisional application until you file for non-provisional within that 1 year time frame. So let's say today is August 13, 2024, you file today for a provisional application. You have to file for non-provisional before August of 2025 of 12th or 13th, because you get that 1 year. If you pass the 13th August 2025, then you lose that provisional application date and we will not see what you filed because it never got formalized for an examiner to examine this. Make sense? Yep.
Does we have one more question from the chat. Dr. Eugene says, can you speak to the range of variants you are allowed going from a provisional to a non-provisional?
What do you mean by range? Trying to understand that.
Oftentimes, it's often understated that once you file the provisional, that you can't add in like the equivalent of new claims and things of that nature. So your what you submit from provisional to not when you're going from non-provisional to provisional, if it varies too much, you don't get that original filing date, from my understanding.
Yes, so you're right. And so this is where we encourage people on putting as much detail in provisional, the specification, the description, add everything that you think of, right? You don't have to formally form the claims because claims can take a lot of time to really think through it. So it's always good to add as much information. And you're right. If let's say after like just before the year ends and you're filing for non-provisional and you could discover some improvement that was not discussed in the in the provisional application, then that improvement is not going to get the date of provisional. Then it's going to be the date that non-provisional was filed. So I'm trying to think of a simple product that will help clarify that. Um, let's say you had a engine that was, had 10 teeth of gears, right? Now you decided that, oh, maybe, adding 14 will smoothen the process of how the gears will work, just throwing it out. So you added 4 gears. But that 4 gears of improvement that you made that can improve the efficiency of the, output of whatever it is, then you might not get for that. So you have to basically think through everything and try to add that information in the provisional patent as much you can. Maybe this example was not the best, but or you could think of pharmaceutical drugs. Let's say there were 4 ingredients and 4 ingredients in the provisional patent, and this drug basically reduces the headache. But now you discovered a 5th element that needs to be added. So then that 5th element will not get the priority date of the provisional, basically. That will have the priority of not whenever you file that. That's why we encourage that don't wait till 1 year. If you figured it out, everything is set, you can file for non-provisional in next 2 months. And you still, and that 5th element that you added, and in 2 months that you file for the application, you'll get at least that date. So you didn't wait for another extra 10 months before, you had the expiry. Hope that helped answer that, Eugene.
Yes, thank you.
And again, as you see here, once the non-provisional application is filed, it will be examined by the examiner at the patent office. And 18 months from that earliest filing date, there will be a publication out to the public, basically, so they can have access. So that's when you can search in Google. And usually there are patents that people get within a year, because they file for fast track, and that there are some additional fees for that. So what happens is, I have personally seen Google sometimes find special expedited process where they put for the application, and as I mentioned, it's 18 months before it get published. What happens is, if they don't get the patent, they don't want, like, if the examiner figures out everything that, okay, this invention is already been there, it will never get published, so it will never come out also. So that's the other way that Google strategizes their patent applications. So sometimes some of the stuff is never out there. They have so many innovative ideas. So let's jump quickly, run through the resources. So that was all about all the 4 intellectual property. So if you go on USPTO's website, you will see that we have the public events here. If you click on it, you'll see all the sessions, free sessions that we have. And then USPTO in your region, you can click here, you will see what resources we have in the state of Florida. And then here's the patent fees that I think these slides are not updated, but this is 60%. And this is 80%. I know that. So I think we have to update that slides. And this is also, as I mentioned, file no more than 4 previous application, then they get the micro entity status. And small business is basically defined by less than 500 employees or a nonprofit organization. And then again, their income should not be greater than 3x of median income. And you can find all that on this link. If you click on this link, that the PDF files I have, you should be able to access this. And then we have, so we have 5 offices right now currently. So if you see the headquarters, Alexandria, Virginia, then we have the Detroit, Michigan here, Dallas, Texas, and then we have the Denver, Colorado, and San Jose, California. So we have these 4 satellite offices in the country. And then also exciting news, we're going to have the 5th satellite office in Atlanta, Georgia here by end of next year. So end of 2025, we're going to have that office running here. And so these are the patent trademark resource PTRC centers that we have. In Florida, I think there's the one next to is the UCF campus as the PTRC center. So if you need any kind of help in patent filing or applications or what forms I need, you can make an appointment there and go there. That's the best way to really get your answers. But there are other resources too. It's just not by visiting them, but that's always helpful. In Florida, here are the few, I think, information that you have in Broward County. There is a main library. You can go there. These are some of the resources. As I said, University of Central Florida Library. And then we also have some USPTO video library where you can go watch some videos. If you don't want to attend those patents or trademark 8-part series, we have videos here that you can watch at your convenience. But it's always nice to attend those events because you can ask questions and they get answered there, which is amazing. And we have amazing team in those presentations. And then here are everything that you need to know on our website, get started. Tons of information. You just have to navigate through this to see what you're looking for. I also highly recommend sometimes to people that if you're new to it, there is a, let me see where it is. Before you apply, I'll pull up the website to show you quickly. When you don't know what kind of intellectual property you possess, there is a tool on our website that can filter it and tell you what all you can do. So, and it's just I think 5 to 6 questions. You answer it. It's very simple, and it will let you know that you might qualify to apply for trademark, copyrights, or all 3, not trades, and trade secret too. We have startup resources. So this is where you can just search on this Google, the search uspto.gov, any kind of startup resources, and it will spit out all this information. There is more access for the startups. There's a lot of information here down that you can, federal grants, any small business administration loans that you can get for your businesses or anything. Tons of information for finding access capital, find funding. And again, we also have the IAC, which is the Inventor Assistance Center, where you can call between those hours to this number. And this basically center is to help you assist with forms and application. They will not help you with coming up with any help with the claims, drafting, or anything, but they will help you fill out the forms, what fees, everything. And these guys are basically retired or examiners who just want to help the public and educate them on filings and fees and any other process. Same goes with the Trademark Assistance Center, same thing. We also provide pro se assistant programs. So if you type uspto.gov and pro se patents, you'll find tons of information. People who are registered patent attorneys and agents who want to help, they are here to help you guys. We have pro bono programs. We also have a law school clinic certification program. So you can click on any of this if any one of you guys are interested in, pursuing. Again, pro bono, this is the whole map. Law school program. So we have trademark schools, patent programs, and then trademark programs. And you can find all this information on our website. And then these are the events that when you click on that events that I mentioned, this will talk about all the events that's going on. They're all free to register. Excuse me. And that's it. And if you have more questions after this presentation or after, you can obviously email us at Eastern Regional Outreach Office, and we can help you get answers for that. But if you have any more questions, feel free, we can try to answer that.
All right, thank you so much. This is very, very informative. I do not see any questions in the chat, but we'll hold off for 1 second before we convene this lunch and learn. Again, everyone, we will be back next Tuesday for those who are registered for the next part in the series. This has been very, very informational. The slides, we do have those. We will send those out to the registered participants. In terms of the recordings, I know someone asked about that in the chat. We are getting our membership site registered so that the recordings will be accessible to our members. Membership is free at the moment, so you can certainly go ahead and register officially with us as a member if you have not done so already. So we can, yeah, go ahead.
I was sorry, Jerry. I was gonna just quickly also add that the one that I was mentioning, this is the website. Like if you went on uspto.gov and you just say identify what kind of IP you have, you click on it, and then you just answer this 6 questions. And when you select, we'll just do it just on the spur, just to show you quickly. I'll just say, and it will spit out so you will understand. You have to just read those questions and answer them. I'm just gonna go through so you can see the end result of it. And not reading all of it, but you can see, and then you can review your responses, make sure you answered them the way you thought of, and then you'll see the results. So this is how it will say that you can copyright it, you can trademark it, you can trade secret it, you can do a plant patent, utility patents, but no design patents. So you just have to read through this question. I just ran through just to show you guys how it looks at. And then there's this advanced IP identifier where you can also do more on that. Thank you, Terry.
Okay, great. In the chat, for those who are interested, if you are not a member, I put the link in the chat for you to register on our website, which is Black Innovation Florida FL. So blackinnovationfl.org. And then you can click on the link that says join us. And there's a secondary link that says register as a member, and you'll be able to register. All right, so we are going to go ahead and convene for the day. Thank you all for attending, and we will see you next week.
Thank you very much.
Bye-bye.